But my father-in-law again was telling me that I couldn't get back into my children's life until I was stable, and I understood that. But again, I was grieving and I started doing drugs, and I just, I got stuck in that predicament.
We're live in court as Melissa Pays faces the music for multiple charges. With her freedom on the line, she's banking on a plea for probation. But the state is standing firm. Is this a genuine turnaround or just a performance? Let's find out.
All right, the court is calling 2025 CR 014167, State versus Melissa Paez. Can I have parties announced?
Robert Maurer for defendant.
And are you Ms. Paez? Just 1 second. Odyssey has been extremely slow. I know
One of
that's
us not
nothing
speak ill
new.
of Odyssey, Judge.
So let me see. All right. And you're Ms. Paez, correct? All right, you entered a plea of guilty on January 21st. The enhancement was waived. The PSI was waived. The TAP evaluation was expedited. Counsel, have you received, and state, have you received the TAP evaluation?
We've received it, Judge.
Any objection to the TAP evaluation, state or defense?
No.
Then according to your plea bargain agreement, punishment is to be assessed at 10 years in the prison. There's a $1,200 fine. State is opposed to your application. This is running concurrent with 2025 CR 008396. The state is taking in consideration 2025 CR 014168. Was there a plea on the 2025 CR 008396 case?
Yes, please.
Could I have the plea paperwork on that, please?
Second
Yes, there are
defendant.
2 cases.
Yeah, I'm sorry, I wrote down the one.
No problem.
What's the name?
Paiz, P-A-I-Z.
All right, and the court is also calling 2025 CR 008396 as well. And state, do you have any witnesses you're opposed? Defense, any witnesses you're opposed?
No, Judge.
All right, state, you're opposed. I'll hear your argument, but before we do that, for the record, in cause number 2025 CR 008396, there was a plea of guilty to count 1. The enhancement in count 2 was waived without objection. And according to the plea bargain agreement in that case, punishment is to be assessed at 10 years in the prison. There's a $1,200 fine. This case is to run concurrent with 2025 CR 014167, taking in consideration 2025 CR 015020 and 2025 CR 015019. All right, the court will hear argument.
She would be a good candidate. She's done 2 trips to prison in the past, but more importantly, crimes she's had in her history of crimes of moral turpitude. She's also involved in people's information. Based on the TAP evaluation, it appears Ms. Paez is not motivated, and in the state's opinion, motivation is the biggest driving factor for someone to be successful on probation, so because of this reason we lost.
All right, defense.
Judge, I spoke with Ms. Paez and she wanted me to speak on her behalf. So she informed me, and I think it's noted in the TAP evaluation, she has 4 kids and they're currently in custody of the father-in-law. And apparently she had congenital heart failure and epilepsy. So while she was in the hospital, the kids were removed from her custody. I would anticipate if the court grants her release, there's going to have to be some sort of CPS plan before she can get custody of the kids. She informed probation, informed me she planned to live with a friend of hers. She did mention, I mean, she's had prior criminal convictions for probation for drug use and indicated use of amphetamines and marijuana. But according to the TAP evaluation, none for 5 years. She would like to ask the court for probation so she can get out and try to take care of her kids and give her a chance to get back on track and hopefully stay out of trouble. So I'd ask the court to grant her application for probation.
All right, is there anything you wish to say?
I would be.
Well, here's the thing, before you say anything, I would have to place you under oath, and the state would have an opportunity to ask you questions. So do you wish to say anything? It's up to you. All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, I'm gonna need you to speak up so I can hear and probation can hear. And so that the state can hear. All right, if you'll state your name for the record.
Melissa Renee Pius.
All right. Whoever wishes
Melissa,
to
what would you
proceed.
like to tell the judge about why you think you should be given an opportunity of probation?
I think that I should be given an opportunity of probation because I have been incarcerated twice in the past, but I do have children out there and I do want to be in their lives. The only way I'm going to be able to get back in my children's lives is if I get back on the right track. And in order for me to do that, I know what the consequences come if I take this probation. If I mess up, I know that I'm going to have to go back and do a lot more time. So I know that. But the longer that I wait to get my life on track, I'm not going to be able to have my kids back. And I need to do that. When I get out, I have 2 job offerings, one at a Valero and one at a hotel. Both of my friends are offering me jobs there immediately. And I have no issue with submitting drug urinalysis. I have no problem doing none of that. And I just would like to be given that chance.
Pass the witness.
Any questions?
Ms. Pius, you mentioned your children. Were you thinking of your children when you committed these offenses? No. How is the court to believe now that you're gonna use your children as motivation? I would be successful on probation. I was grieving whenever I committed these crimes. My mom just passed away a year ago, this last month, just passed away. So I wasn't in the right frame of mind. I wasn't thinking about anybody. I was being selfish. Thank you.
I don't have anything further.
All right, I have a few questions.
Yes, ma'am.
So I don't understand how your grieving translates into your committing crime. And the reason why I'm asking, I'm trying to understand your thought process.
Hey, when my mom passed away,
Does anybody have any Kleenex over there? Okay.
my mom passed away. I can admit that I just spiraled down just immediately after she passed away. Like I couldn't handle it. And then I needed help paying for my brother's bills whenever I got out because I was living with him. I rolled out to Bevo, and I just got into something that was easy and it just stuck. And that's why I did it, because I just wanted to help, but drugs was never my addiction problem. It was the fact that I needed to help and I couldn't, but I was
So sorry, excuse me, miss, you're gonna have to take a seat. All right, you may continue.
I was grieving, and I can admit that I did start doing drugs, but like I said, drugs has never been my thing. So when I did that, it's just like when I got stuck doing that one thing on that drug, that it just kept going from there, and I just kept
And
going.
where were your children doing all of this?
They were my father-in-law. But my father-in-law again was telling me that I couldn't get back into my children's life until I was stable, and I understood that. But again, I was grieving and I started doing drugs, and I just, I got stuck in that predicament. And my parole out to is Bevo, and they're over here in San Antonio.
So your parole offers what?
I paroled out to Bevo where my mom lived,
Mhm.
and my kids are here in San Antonio.
Okay. All right. Anything else?
No.
All right, so here's the thing. I don't think you're appropriate for probation. So I'm not gonna grant your application. What I'm gonna do is I'm gonna find you, and cause number 2025 CR 014167. Court is gonna find you guilty. The court will sentence you to a $1,200 fine. Time and money will run concurrently. Court will request the therapeutic community. This will run concurrent with 2025 CR 008396. Take in consideration 2025 CR 01468. There's to be no contact with, I'm sorry, state, you may be excused. There's to be no contact with Mission Mitsubishi at 9800 San Pedro. And Charlene Hill. There's to be no unsupervised contact with minors. And the court will sentence you to 9 years in the prison and give you credit for any time served. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Yes. Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And cause number 2025 CR 008396. The court is going to find you guilty. Court will give you credit for any time served. Court will sentence you to 9 years in the prison. Give you credit for any time served. There's a $1,200 fine. Time and money will run concurrently. Concurrent with 2025 CR 014167. Taking consideration 2025 CR 015020 and 2025 CR 015019. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? And I'm sorry, the court is also going to order the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. The therapeutic community is designed to help you with whatever issues you may have. It's to help you hopefully come back into society, rehabilitated, and be successful and not get sent back. I don't have any jurisdiction to force them to place you in the program, but in the judgment, it'll see that the court requested the therapeutic community. It won't increase the time that you're in custody, and you'll need to request it as well. Do you understand? All right, good luck to you, okay?
Thank you, Judge.
Thank you, counsel. All right, so what is happening with this case, counsel?
Your Honor, this is my first appearance. I substituted in for Roland, had health issues. He hired me about a month ago. I've now seen all the discovery. I came and the file is not here. The prosecution says the docket says.
Well, just one second. Could I see the state on Rafael Rodriguez? Norma? Yeah.
Okay.
Wasn't this case previously set for a PTD?
So we reached out to the prosecutor, it's Hunter Morris, who has developed this fraud.
Mhm.
He stated he would not extend PTD, but I
Okay.
gave him defense contract info so they can do it.
Okay. All right, Ms. Ferguson, I need a 30-day reset for discovery and state. On that date, you need to tender an offer.
Yes, sir. Enough.
Thank you. Okay, Your Honor.
All right, they're gonna give it to me just.
May we be excused from here?
Once he signs the reset form.
Thank you.
All right, what's the date?
Second, Judge.
All right, April 2nd.
April 2nd, it is.
Thank you.
Okay.
All right, court is calling 2025 CR 0048887 State versus Juan Alberto Martinez. Can I have parties announce?
Steve. Robert Featherston and Pauls for Mr. Martinez.
And are you Mr. Martinez?
Yes, ma'am.
All right, Mr. Martinez, the court had a chance to, as I've told parties, I know the law on this subject matter, but whenever anyone gives me case law, I always like to reread it, to re-review it, because sometimes it says something different when you interpret it. So I've had a chance to do that. I do recall all of the testimony from the witnesses that were called. And based upon the case law, based upon the testimony for the witnesses, the defense's motion will be granted. Is there anything else?
Judge, the statement impressed upon the facts.
All right. And just one moment. I will most definitely give you all the findings of facts and conclusions of law. But what the court will say is the court, with regards to any statements that were given, the court is finding that he was under arrest. It was not a detention, it was an arrest. And in the findings of fact and the conclusions of law, I'll state what the court is basing that upon. With regards to the arrest itself, the court is finding there was no probable cause for the arrest at all. And the court will submit findings of fact and conclusions of law as to why the court came to that conclusion, and the facts the court based those conclusions upon.
Your Honor, may I address the court?
Yes.
Judge, will your ruling include that his identity is suppressed? I mean, that's really the operative issue here,
Mhm.
that he had no probable cause or reasonable suspicion to determine his identity.
All right. So what the court is going to do is the court is suppressing the arrest. The court is suppressing any statements. That's what the court will do.
Okay, thank you, Your Honor.
All right. Is there anything else?
No, Your Honor.
All right. Thank you.
Judge, I think the state has not indicated whether they want to proceed with the case or not. If, and I'm assuming that we're still in the
I don't-
process.
Believe they have anything to proceed on. Everything has been suppressed.
Well, I agree with the court, but I haven't heard the state say that whether they're going to appeal or drop the case or.
And that is what I will need to check on. If this will be any kind of appellate issue or anything like that.
All right. If you all could find that out today, because is this the only thing that's holding him in
It's
custody?
the only thing that's holding.
Yeah. So if y'all can find that out, I will get an answer from them today.
Your Honor, you're most kind.
All right. Thank you.
May we be excused, Judge?
Well, if you will make sure you come back so we can have an answer for you. I say we,
I'll
but
hit
the
the other,
state.
I'll put you on the circuit.
All right. Thank
Be right
you.
back.
Thank you. You're welcome. All right. So what's happening with the VTC?
It's the evaluation is scheduled for March 27th. So we had hoped it would happen before today, but it did not. So we did confirm with probation, it's scheduled for March 27th. My client wanted me to again ask for a bond.
Does he not have a bond?
No, because he didn't appear and when he was awaiting the Veterans Treatment Court, so you had remanded.
Okay. I'll address that. Let me just get these dates first. Ms. Ferguson, can you place this after March 27th? It's for a status on VTC.
That's fine.
All right, so that will be March 31st. And have you talked to the state regarding a bond?
No, I had not actually.
All right, if you'll speak to them, if they have no do you have a motion in file?
No.
If you'll speak to them, if they have no objections to an oral motion, I'll hear it today.
Okay, thank
All
you.
right, thank you. Just have a seat.
Thank you, ma'am.
You're welcome.
Judge, just for your edification, it's a motion to revoke and a new case of DWI third. We're gonna run CC 4 years. No probation.
Okay.
Okay, thank you.
All right, the court is calling 2026 CR 002-947 State versus Alan J. Hernandez. Could I have parties announced for the record, please?
State.
James Seeloff for the defense.
And are you Mr. Hernandez? Probation, there's no application in this case.
No.
All right. Counsel, have you received all discovery that you review with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you understand you have a right to have a grand jury review the evidence in this case and make a decision on whether or not to hold you over for trial?
Yes, ma'am.
And did you understand your attorney has the right to have 2 days pass upon the presentation of the information and 10 days to prepare for trial? Did you understand by entering this plea, you're giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes.
All right, so the rights I've explained to you, do you understand
Yes,
this?
ma'am.
Are you giving up those rights?
Yes, ma'am.
Okay.
Are you intending to give up those rights and enter into whatever plea bargain agreement you've reached?
Yes, ma'am.
All right. Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the information with your attorney? Did you understand it?
Yes, ma'am.
Counsel, are you waiving the reading of the information?
Yes, we are.
State, are you proceeding on the information as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with driving while intoxicated, third or more. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I believe he was.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea? Satisfied with the way you've been represented?
ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 4 years in the prison. There's a $1,400 fine. This will run concurrent with 2022 CR 2976. Did you understand that to be the plea?
Yes, ma'am.
Defense,
That's our agreement.
state. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No,
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, sir. Proceed off receipts, exhibit 1 and all attachments.
no objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he's 61 years old and he has a problem, obviously, and together with the motion to revoke, we think this is the only way to go.
All right, the court will sentence you to 4 years in the prison, give you credit for any time served. There's a 2-year driver's license suspension, $1,400 fine, time and money to run concurrent. This will run concurrent with 2022 CR 2976, and the court will recommend the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we're proceeding in 2022 CR 2976. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Alan J. Hernandez who was placed on community supervision in 2022 CR 2976 for the offense of driving while intoxicated third or more on June 14, 2022 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 21st day of January 2026 in Bear County, Texas. The defendant, Alan J. Hernandez, committed the offense of driving while intoxicated in violation of condition number 1.
How do you plead to that? True or not true?
State will waive the remaining allegation.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 1, the court will find it true, grant the motion, and sentence you up to 4 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to grant state's motion and sentence Mr. Hernandez to 4 years in prison.
To run concurrent with the. Okay, yeah, that's our understanding.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, thank you. State, you may be excused. All right. All right, the court will grant the motion. The court will revoke. The court, as previously stated, is finding violation of condition number 1 true. Court will sentence you to 4 years in the prison. This will run concurrent with 2026 CR 002947, therapeutic community, and 2-year license suspension. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
All right, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing,
Credit for time served? I'm
yes,
sorry.
you'll receive credit for any time served.
I didn't hear it the last time.
Oh, that's okay. Legally, you're entitled to any time that you have served. You understand? All right, we can go off the record. The therapeutic community, I don't have any jurisdiction to have them place you in the program, but on the judgment, it will show that I'm requesting that for you. You really need to do your best to get in that program because you have an alcohol problem, right? And if you don't solve that, what's going to end up happening at some point, you're going to be listed as a habitual. The minimum will be 25 years, or either worst case scenario, you're going to end up driving and killing someone. All right. All right. Good luck to you. When you're released from custody, if you can't find a sober support house to live in, you come back here. I will pick up the phone if I'm still here and find a place for you. Okay. All right. Good luck to you.
I suggest AA.
Mhm.
Good program. Okay, good luck, sir. Good luck, man.
Thank you.
In a final plea for his future, the judge sentenced Hernandez to 4 years, emphasizing that without treatment, he faces a potential 25-year habitual sentence or worse. It's a powerful ending to a difficult case. If you found this breakdown insightful, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
And there needs to be a bond set on each one, correct?
Yeah, I don't represent him on the other one, but I'm fine to request that. Yes, Judge. Somehow he has 2 lawyers. I think it might have been I got off the wheel last summer for a while. It may have been during that time.
Norma, You want to call the defense attorney on the other case and see if there's any objection for Ms. Chacon being on both? That will probably be easier for everyone.
Was it Brandon?
Mhm.
Yeah,
I think I asked him last time.
and he didn't care. Okay, right.
All right, court is calling 2025 CR 009908 and 2025 CR 009982. Do I have parties announced for the record?
Brandon British, state.
Merit Chacon for Mr. Moore.
And are you Mr. Moore?
Yes, ma'am.
All right, so to address the preliminary matter, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yeah.
All right, you can lower your hand, state your name for the record.
Troy James Moore.
All right, and the cause numbering in 82, your attorney is listed as Brandon Lopez. It's the court's understanding that he has no objection to Ms. Chacon being placed on both of your cases. Do you have any objection to his withdrawal?
No.
All right, and Attorney Chacon, do you have any objection to being placed on both of the cases?
No, Judge, it makes it easier.
All right, thank you. And we're off the record just briefly. All right, it's the court's understanding that there is a oral motion for a bond to be set in each of these cause numbers. Is that correct to both parties?
Yes.
Correct.
And defense, I'm sorry, state, you have no objection to the defense's oral motion?
Not at all.
All right, defense, do you have any evidence for the court?
I need to call my client only for the purpose of him addressing not coming to court.
All right, and you're still on oath. You may proceed.
Mr. Moore, can you explain to the judge why you missed court in November? I believe it was November.
That was on Friday, but I came here, actually I came out on Friday. It's Thursday. I get the dates mixed up on one day. I was outside there and the door was locked.
Mhm.
So, and then that's why I missed out one day.
So when you came on Friday, there was no one here to check in with? Is that
Right, right.
Okay. Nothing further, Judge.
Okay, then it's the court's understanding that you all have agreed to a bond or asking me to follow an agreement?
Yes, Judge, I believe our agreement is, he's currently on bond for the 1 to 4 case at around 3,500. Because he was not showing up to court, we'd ask that you increase that bond to 7,000.
And then what is the bond in the 82 case?
It's 2,000.
All right, and does he have any criminal history, violent history?
These are a few arrests for assault, Judge, but it's mostly thefts, drug use, things like that.
All right, and has there been any conviction for any violent offenses? And I'm looking it up as well.
I don't believe so, but I don't have the history in front of me.
Odyssey is so slow.
Mhm. I do know that he lacks the means to make a very high bond.
Okay.
And the Veterans Treatment Court person is here so we can make sure he knows when his appointment is if he gets.
Good morning, Your Honor. How are you? So he is scheduled for an assessment on the 27th of March. So I'm just
11
here.
a.m., right?
Yes, I'm just here to encourage now that if we do make bond, make sure to report here on the 3rd floor, okay? And we'll reach out to you.
Okay.
All right, and what date is that?
March 27th, Your Honor, at 11 a.m.
Did you get my phone number?
Yes, I'll make sure you code with the card, okay?
Thank you, ma'am.
Perfect.
I'm sorry, March 27th at,
At 11 a.m.
all right, state.
Judge, I'm pulling up his criminal history in Barrett County right now. If I can have just a minute.
Sure.
Thank you, Judge, my fault.
I guess their computers are just as slow as yours.
Yes, mine is still
That's the
circling.
county way. Long for the old days, the dot matrix printed TCIC and CIC and
Yep,
where you had to rip the sides off.
yes.
I do see conviction in 2020 for ABR.
And do you have a place to stay?
Yes,
And is that with someone?
Yes,
Are there any minors in the with, is that a relative?
yes.
And who is it? Is your mother, father?
Father.
Okay. All right, this is what the court is going to do. In 2025 CR 009908, the court is going to find that the defendant did not willfully fail to appear. The court will set the bond at $3,500. The court is going to order supportive outpatient treatment, waive the fees. There's to be regular UAs, waive fees. And as a part of your condition of bond, I'm going to order that you meet with Veterans Treatment Court on March 27th at 11 a.m. Is there anything else with regards to that?
Say good.
No, thank you, Judge.
All right, and then in cause number 2020 CR 00982. Odyssey says no match found.
They dismissed that case then, Judge. We can.
The court and that cause number is going to set your bond at $2,500.
The one for 3,500, one for 2,500, right?
Yes. For
Okay.
3,500 and
All
for
right,
25.
all right. Thank you.
Again, the court is going to find that the defendant did not willfully fail to appear. Court is going to order supportive outpatient treatment, waive the fees, regular UAs, waive fees. And the court is going to order that you meet with VTC on March 27, 2026 at 11 a.m.
Okay.
Is there anything else from either side?
No, you aren't.
All right, off the record, VTC?
Yep.
If for some reason he's not able to bond out, is there any way you could see if it could be expedited?
100%. So we can actually, we had it set up already through our contact in the jail to where we'll do a Zoom. We do about a couple of weeks to where she'll reach out, get a date, and then we'll have our VJOs get on the Zoom as well with me. And we'll knock it out. So we'll, depending on what plays out here, that we'll jump on either.
All right, and if you contact VTC and make sure they know whether he's out or not.
Okay.
All right, is there anything else?
About the outpatient thing, so when I bond out, I was, he said outpatient, something like that?
Yes, what's going to end up happening is pretrial services will reach out to you and they will give you what they approve for outpatient treatment. But since you're a veteran, they should allow you to go to the VA for that.
That's kind of proof of that, right?
Yes.
Okay.
And if there's some issues or you have questions about anything, make sure you contact your attorney, or either if you get confused on dates, you can come back here and the clerks will let you know where you're supposed to be.
So I get a whole, the pretrial services when I bond out and they'll guide me from there, right?
Yeah.
Okay. All right.
All right, thank you.
Thank
Thank you, ma'am.
Thank you.
ma'am.
You're welcome. All right, on James Lord, I need a certification of appeal.
Judge, I
Mhm.
need a coach on this.
Yeah.
This was an MTR. Mr.
Mhm.
Lord couldn't make it over. Last time we were going to put him in we're going to withdraw the MTR and put him in, sorry, the program name. Anyway, we had to have him reevaluate to see whether he would go to the ISF cognitive,
Mhm.
which he is in agreement with going, and they were going to withdraw the MTR, but you wanted us to come back and make sure the evaluation was good, that this is what the court was going to do.
Okay.
And unfortunately, you and I are the only two people, the same people that were here that day. The probation,
To the only people.
the probation was somebody else and the state was somebody else.
Okay, just one second. But I do remember this case and there were some cognitive issues.
Cognitive issues, and I've spoken with him on Zoom a couple of times, and he wants to go to the ISF cognitive to get it over with.
All right, so the evaluation has been completed?
Yes, ma'am, from what I understand.
Just one second.
I just can't remember what the other program they were trying to put him into, but he wouldn't qualify for that. My notes are not.
It's probably like DDRF or something. All right, so this is what I'm going to tell you. You've got to make sure that you stay in contact with probation. You can't disappear, you understand? Otherwise, what's going to end up happening is another motion to revoke is going to be filed. And then what you're looking at, according to the plea bargaining agreement you reach, is 4 years in the prison. You understand? Not saying that I would give that, not saying that I would revoke you, but that's what you're looking at if a motion to revoke is filed. You understand? All right, Ms. Abrams, on this case, James Lord,
Yes, Judge.
my understanding, I'm so sorry, everyone, just give me a moment. So probation on this one, there's to be a withdrawal, is that correct?
Judge, I don't know about the withdrawal part of it. I'm not quite sure about that. I just know that, there was a top revision done for him to go to state ISF. I do have the notes that the CLO, when I was in my absence, put into our system, if you'd like to review.
Yes, no, I have it. He was supposed to be evaluated for cognitive.
So they did the revision for the TAP, and, we just need to get the paperwork done for it.
Okay,
So, is it to be withdrawn
it
or?
was supposed to be a withdrawal
Okay,
and
you can
then,
do the withdrawal.
all right, thank you. And so his conditions will be altered and amended for a cognitive ISF.
Okay, Judge.
All right, thank you. All right, do you have any questions about anything?
You answered pretty much everything I asked.
Okay, so you're gonna remain in custody till transfer? All right, thank you.
Big Jim, maybe excuse?
Yes.
Thank you.
All right, good morning.
Morning.
All right, so on this case, where are we on defense? You're receiving information from the state.
Your Honor, you hit the nail on the head. Mr. Prater is gonna try and get a video that was taken by a witness, which will be defining in the case specifically towards operation. And then I'm also working on my end on trying to get some things as well. It looks like a third setting, but I think it's really a second.
Mhm.
But in any case, whatever you want to give us is fine.
All right, Ms. Ferguson, I need a 45-day reset for discovery. Because I know it takes a while when you're dealing with witnesses.
Sounds good.
All right, we're gonna come back on April 16th. And it's for your attorney to have the information she needs to proceed.
Okay.
All right, do you have any questions?
I don't know.
All right, thank you. Just have a seat and she'll bring the reset form to you.
Thank you, Your
Thank
Honor.
you. You're welcome. Don't fold your arms. It makes everybody, deputies get nervous. Everybody gets.
Oh, okay. I feel tense. I'm
Yeah.
frustrated. I'm
Oh,
sorry. I'm just.
well, I hope you're not frustrated.
Not with you. It's the situation, the whole case in general.
All right, do you need to speak to your attorney about that?
No, I gotta give it to the Lord.
Oh, yeah. I always tell people, let go, let God.
Amen. Yes, ma'am.
Thank you. All right, the court is calling 2025 CR 015731 State versus Mariah Munoz. Could I have parties announced?
Rolando Waivers with Munoz.
And are you Miss Munoz?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Munoz, did you review the application for
Yes.
deferred adjudication
Yes,
with your attorney? Did you understand it and sign it?
Can you speak?
yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are good.
All right, Ms. Munoz, did you review the court admonishments with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes.
All right, you're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason I do not follow your plea and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with defenses?
Yeah, she has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Munoz, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No,
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
All right, if you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand that?
Yes, ma'am.
According to the plea, there's $1,000 fine probated, and the state is recommending deferred adjudication. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes.
Did you review the waiver of appeal paragraph? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years, 100 hours community service restitution, the DOEP course, and MRT. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, you have to say exhibit number 1, including all of its attack.
No objections, Your Honor.
All right, did you state you may be excused? Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept it to evidence, states exhibits 1 and attachments, and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. All right. All right, and what are we here for today?
Judge, I think this is a probation update. I think he just was
Yeah.
accepted into the Veterans Court, right?
Yes, sir.
Congratulations, that's a good program. So what will happen is they will be in charge of your conditions of probation. So whatever I've ordered, if they decide they want you to do something other than what I've ordered, or they want you to do less than what I've ordered, that will be completely up to them.
Yes, ma'am.
All right. So just make sure you keep all your appointments with them, okay?
Yes, ma'am.
And when you graduate, I'll show up to your graduation.
I look forward to it, Your Honor.
All right, thank you so much.
Thank you, Judge.
You're welcome. All right, what I can tell parties is I'm not gonna make a ruling on the motion to withdraw his plea, because there are only specific reasons for why a plea is allowed to be withdrawn legally. But your attorney has filed a motion to withdraw.
Okay.
And Cindy, we're on the record, correct? All right. And State, do you have any objection to the defense's motion to withdraw?
Withdraw.
No, to withdraw from,
Full.
all right. Mr. Pena, do you have any objection to the your counsel's motion to withdraw as counsel?
No, ma'am.
All right, so that will be granted. You're excused.
Thank you, Judge.
Thank you. All right, just have a seat. So why were you late for court? All right, so here's the thing. Docket starts at 9, okay? All right, where are we on discovery, counsel?
State has got to check out potential reimbursement.
Mhm.
What he finds out could affect the causation in this case.
All right, Ms.
But-
Ferguson, I need a 30-day reset for discovery and state your tender and offer. Okay. Thank you, Mr. Woods.
Good. Could we do this maybe like in 28 days? I'm having knee surgery April 1.
Okay, he wants it done in 28 days. Let me ask you this, State, when you think you will have the information for defense counsel?
It's fine. Look at the video of the lunch. I think that there is a Kodak camera that is relevant to the issue.
All right, Norma, let's recall this back in 3 weeks, and if you all can't do it, just confer off docket, let me know, and it'll be reset.
That'll work, that'll work.
All right, what date? 3 weeks.
March 23rd.
All right, March 23rd. Thank you. You're welcome. All right, so in this case, have you received all discovery?
I have, Your Honor.
And was an offer tendered?
Yes, ma'am.
And how old are you?
I'm 36, 70.
You believe? All right. On this case, if we can set this in 45 days for a plea deadline date.
April 16th.
All right, so that would be the plea deadline date.
Sounds good, Your Honor.
Is there anything else?
Your Honor, I filed a motion to amend his bond conditions. I conferred with the state and they have no objections to it. He's currently on partial house arrest. He has no violations. So we're requesting that it be changed to just tracking only.
All right, so just a second before we do that. Well, no, I haven't. Well, I don't know.
It's been a while since I've seen you. Your face looks thin.
Yes.
I mean, it just does.
Well, you know what I've done? Sodas, sort of like off the table.
But did you drink diet sodas before?
No, I think diet sodas just don't taste good to me.
Really?
To me, if you're gonna go, you.
Yeah, that's the way my brother is. I drink them, not all the time, sometimes.
But now my thing is, because I don't like breakfast, it just doesn't agree with me in the morning. So I'll do a lunch, I'll do dinner, and I don't eat past 7.
Really?
No, and I'm telling you, sometimes when I have other things that I have to attend or, other charity things I have to do, it makes it difficult, but I don't eat past 7.
And you're not diabetic?
No.
I'm diabetic. Eating past 7 thing, that my doctor would love it. I couldn't do it. No way. But
No, I don't.
it'd be great for you.
Well, I read a book and I try to go to bed.
There you go. Yeah.
But I remember reading an article about Lenny Kravitz. And there's a certain time that he doesn't eat past. And so the person who was writing the article said, yeah, but what do you do if you get up in the middle of the night, like 3 a.m. and you want something to eat? And he started laughing. He's like, I don't wake up at 3 at night, but he's like, if I did, I just drink some water.
Right.
Yeah. The other key is if you drink an 8-ounce glass of water and eat an apple before dinner, you won't eat as much.
Is that true? Really?
I mean, if you think about it, you'll probably be full.
Yeah. That's it.
We're having weight conversations. How are you doing this morning? All right. So what is happening with this case?
Judge, the state has fully complied with all discovery requirements. And so
Did they tender an offer?
they did.
Okay.
Yes.
How old are you, sir?
55.
All right, Ms. Ferguson. Set this for a plea deadline date in 30 days, please. And you need to make sure you're on time for court, okay?
April 2nd.
All right, once you sign the reset form, you're excused.
Thank you so much, Judge.
Thank you.
Keep it up.
Oh, I'm gonna do my best. And you know what? I will tell you, I haven't felt it, but yay.
Well, I mean, I'm being as objective as possible.
Okay, I love the objectivity. Don't blow smoke.
You'll have a great day.
All right, you too.
This session highlighted the human side of the bench, but the 30-day deadline proves the court is all business when it comes to the schedule. As one case ends, another begins with the calling of Edward Vera. If you enjoyed this look behind the scenes, hit that like button, share your thoughts below, and subscribe for more jaw-dropping courtroom breakdowns.